on the team members who worked on the model use of force policy will later be summarizing several comments we received regarding the use of force policy that was presented at the last commission meeting, and the commission will be considering again at this meeting. We are thankful for those comments, and they will be also available in the commission package that was published this morning. Excuse me. So I will provide a certification update, specifically the process of reviewing and approving voluntary relinquishment of certification, given a recent decision by the state police to modify one of the requirements for issuing licenses for private investigators. I will touch on some recent outreach and engagement that we do periodically, of course, and provide a summary of the finance and administrative activities of the recent period. At that point, I will turn it over to our Chief Technology Officer, Owen Mayle, who will give you an overview of some of the analytic capabilities that we are rolling out this morning with the help of our new business intelligence tool, which will be available on our website again this morning. So the Massachusetts State Police issues licenses for private investigators and watchguards in accordance with sections 22 to 30 of Chapter 147 of the General Laws. Now, historically and currently, of course, a retired police officer with their training and background, they bring direct relevant skills, of course, to the position of private investigator. The state police, until recently, would not issue a private investigator license to someone who also held a post certification. And that is the main reason we have been receiving a few requests to relinquish certification when individuals would choose to retire and then were applying for a private investigator license. Well, just 2 weeks ago, the state police communicated to us that they have changed that policy and will be issuing those licenses to individuals who may still hold a post certification, but they will impose certain conditions. Instead of this prohibition, they'll apply certain requirements as part of issuing that private investigator license. Those conditions include an acknowledgement form, which has been included in the packet for the commission to just consider. And for reference, I will note that post marks the certification of individuals who leave an agency as restricted as soon as we learn or are informed that that individual has left a police department. We maintain, by the way, that to conduct police duties and functions and carry police powers, an individual must be employed by a law enforcement agency and be certified as a law enforcement officer. So I want to summarize those new requirements that I just spoke about and that the state police recently implemented. Instead of denying an application for PI licensure, if an individual also holds a post certification, the state police requires the individual to notify them of any changes to their certification status. Importantly, they require that those individuals in their new position as a private investigator remain strictly separate from public law enforcement authority. This includes a prohibition to access the Criminal Records Information Databases, or CJIS. Those individuals will be prohibited from acting under the color of law, exercising police powers, representing themselves as law enforcement, or displaying credentials unless specifically authorized by law. In addition, they are prohibited from using their post certification for private benefit. Misuse of such certification and prior police powers may result in criminal prosecution, discipline, loss of certification, and or revocation of the private investigator licensure. As a result of this change in policy, Two recent requests to relinquish their certification have been withdrawn. We also expect that the number of requests for voluntary relinquishment that we were getting will likely decrease going forward. And again, we were getting 1 or 2 a month. It was a slow but steady cadence of those requests. So on that matter, I will provide an update. At the last commission meeting, commissioners might recall that former New Bedford Chief of Police Paul Oliveira had submitted an application to voluntarily relinquish his certification, which is due to expire on June 30th of this year. And back then, Mr. Oliveira failed to disclose a certain lawsuit that he was a part of, which was part of the questionnaire that we used to impart for considering this relinquishment. And because we learned that fact a couple of days prior to the public meeting, we recommended that we put this request on hold until today's meeting. Now, given that recent change in policy, Mr. Oliveira has withdrawn his prior request to relinquish the certification. And as I mentioned, we have scheduled another individual to come before you, and that individual has also withdrawn that request. So moving on, I'll mention 2 recent events and 1 upcoming that fall in the category of outreach and engagement. On February of this year, Jerry Cahill represented the Post Commission at a public interest networking night sponsored by Boston College Law School of Public Interest Law Foundation. The event was aimed at connecting students and interest practitioners doing impactful work. These individuals, these kind of events connect us with potential candidates for summer internships, postgraduate positions, etc., and they are also very well received. Now, also in February of this year, Randy Ravitz and Matt Landry gave a presentation to and answered questions from the Massachusetts Bar Association's Criminal Justice section regarding the mission of the Post Commission. The association describes its criminal justice section as providing a forum for all criminal practitioners, defense, and prosecution to exchange ideas, experience, and positions, resulting in well-balanced education programs and legislative reviews. Finally, this coming Tuesday, Chair Hinkle, Commissioner Luma, Eric Revello Pradas, and I will be in Foxborough testifying before the Joint Committee on Ways and Means. We will be asking the legislature for funding closer to the amount that we requested of Administration and Finance last fall. And I will summarize those figures in the next couple of slides. So I will stay on to provide you with a brief overview of the finance and administration activities of the recent period. Our finance team, I must mention, did not include the treasurer's report in the packet or send it to the treasurer, given that the state is transitioning systems. What we used to call MARS, or the accounting system, is now a new system called Mosaic. And no agency had access to the information warehouse for a couple of weeks, and that's the reason we did not forward the report. However, all expenditures continued being accrued, and we will come back next month with a cumulative report as part of the treasurer's report and the reports on finance and administration. So, as we said last month, we will have unspent funds for fiscal year 26. We're in the process of fine-tuning those figures and our preliminary estimate, and sending those estimates to the state's administration and finance. We know that estimate would be somewhere in the neighborhood of $300,000 to $500,000, and we have settled on approximately $425,000 as our best estimate at this time. And we'll keep you posted during the remaining months of the fiscal year. And again, Eric Revello Pradas will come back at the next meeting with a more detail on the third quarter results for the current fiscal year. Now, for fiscal year 27, I mentioned that we will be presenting testimony in front of the Ways and Means Committee in Foxborough this Tuesday. We will maintain course and pursue our original request, which was $9,590,000. We feel that this is necessary for us to continue on track implementing what we hope to implement soon, which is an auditing and function and the first steps of our certification of law enforcement agencies, as well as meeting some additional needs in legal and the division of standards. Among some of the things that we will highlight is the fact that we have almost entirely eliminated two large categories of expenditures, and that is our consultants and information technology development tool costs, given that we have hired and maintained all of that expertise in-house, and that is a significant cost efficiency approach. I will move on to just give you a brief update on some recent additions to our staff. Earlier this month, Carlton Satchell joined the Division of Police Standards as one of our intake coordinators. Carlton is our fifth individual in this position. We get quite a bit of activity in that area. The legal division onboarded our latest legal fellow, Victor Lobo. He's a recent graduate of the BU Law School and will be with us for a year, for the year fellowship that we normally do. And let me mention here that this program has been very successful for us. Boston University funds the one-year fellowship, and we benefit from the great work that those fellows come and do for us by training and exposing them to adjudicatory cases and some of the multiple areas that the legal team engages in and forward. Now, we have 5 open positions, which we are looking to close by June 30th. One of those enforcement counsel positions is to replace Bill Aiello, who recently left to work for the Plymouth District Attorney's Office. We wish Bill good luck, and given that the nature of the work that Post and the District Attorney's Office do, I suspect we might cross paths in the future. I should also mention that there's another position that is also a backfill. Our data analyst in the certification division will be moving to the West Coast for family reasons, Richard Wanju, and will remain with us until we find a replacement for his position and are able to transition the work that he does to that new position. The other 3 positions, additional counsel, another enforcement counsel, and a data analytics manager, are part of the plan that we had set up for hiring in this fiscal year, and we're hoping to close that plan with as we envisioned. Post currently has 52 staff and are projecting to finish at 56 for the fiscal year. Let me pause here and ask Owen Mayle, our Chief Technology Officer, to give you an overview of the certain capabilities that we will be rolling out as we speak, relative to website searching and data analytics that are facilitated by our business intelligence tool. Owen, you can.
Thank you, Director. Good morning, Commissioners. This morning, I'd like to describe the steps we're taking to release more information to the public, as well as to enhance our internal analysis of the data that we've collected. Starting today, Post will release more analytical data to the public on our website. As you know, Post has been collecting data for almost 4 years, and we're now prepared to share this data in a more graphical and easy-to-use format. Over the next few months, we'll enhance this first release, not only to increase the transparency into complaints filed in the Commonwealth against agencies and officers, but also to show officer certification statuses, commendations, and by adding demographic data to allow the public to view similar agencies, their officer makeup, and the number of complaints based on the size of the agency, location, and population. While this first release is at a very high level, it does serve as a starting point for Post to meet the statutory requirements and to answer questions that we receive from the public via requests for information on an ongoing basis. On this first slide, we're simplifying the data that we already released via a PDF that describes detailed certification statuses. The chart will allow the public to see the certification makeup of each agency or selected agencies by one or more certification statuses and includes the total number of officers certified by Post. The data is refreshed every night, so it is slightly more current than our existing PDFs. And within the month, we do expect that the public will be able to download this information so they can perform their own analysis if they choose. By the way, we have no reason to stop producing the monthly PDFs or the static PDFs if the public prefer to view the data in that way. So here on the slide, you can see all officers are selected, all agencies are selected over on the left in the filter section, and that shows the total number of certified officers of that agency broken down by certification status. In the upper left-hand corner under agency search, you can see that we're looking at all agencies. Okay, next slide, please. On this slide, you can see that we selected two certification statuses, certified and certified SRO, school resource officer. And on the right side of the graph, therefore, has been updated with the relevant data for all agencies that meet that initial filter. Next slide, please. On this third slide, you can see that we filtered by specific agencies. So while we've kept the certified and certified SRO in the bottom left area of the filter by status, in the upper left, we've selected Acton, Boston, and MSP. I will note that this data includes every officer that's currently certified by Post, regardless if they're employed at an agency or currently unassociated. That is, those officers that have recently retired, could be new academy grads that have not been hired by an agency, or those in between positions at agencies. These unassociated officers will have the status of restricted, and Enrique mentioned that a few minutes ago. Next slide, please. On this slide, we've taken the time to look into standards. So the first slide was for certifications, second slide is standards. Here we've broken down the way that we receive complaint allegations, both from the public and the agencies. This allows the public to drill into the complaint allegation by type and subtype. Currently, we have 6 major types that we segregate our data by. And by selecting one of those at the top, you can drill into the specific subtypes below. Next slide, please. On this slide, you can see that bias was selected in the upper left-hand corner, and therefore now you can see the subtypes that are reported to us, whether bias by sexual orientation, gender, or a number of other options that we currently have subtypes for. This is data that has been collected since we've started using a system in 2023. This does not currently include our historical data. The way that it was collected is slightly different than the way we collect data today. So we are expecting to release the historical data very shortly. This data is also based on monthly disciplinary data. So it directly relates to what we've already been releasing on the website for the last few years. Also, as in the certification PDFs, we will continue to publish this data in PDF form if the public prefers to see it in that way. Next slide, please. On this final slide, here is the workload slide. So the current workload of Post by intake channel and by year. I'll note here that Post opened our portal to the LEAs in 2024, and during the year of 2023, when the public portal was opened, we were collecting agency data via email. All of that data was put into our system in the first quarter of 2024. That's why you see the blip here in the data where it looks like we got a lot of complaints. So it has actually balanced itself out. And again, if you look at this data, just to restate, this is based on when the complaint was logged with post, not the actual incident date of the complaint, thus representing workload, not incident occurrence. As you can see, somewhat interestingly, our complaint report load is pretty uniform, quarter by quarter, with the public submitting slightly more complaints than the agencies. So to wrap this up, for the first release of this analytical data, we wanted to touch on each section of POST, our certifications, standards, and submissions. As I mentioned, we'll continue to add to the amount of data that we release to allow deeper dives by the public with the option of downloading the actual data behind the graphics. Thank you for allowing me this time to show how IT is helping POST meet its statutory requirements, and happy to answer any questions you may have at this time.
I don't think I see anybody indicating a question. Let me thank both you, Owen, for that presentation, which I'm sure all of us commissioners found exceedingly interesting. And thank you also, Enrique, and those who worked with you on the information that you provided. And I think with that, we'll move on to the next item on the agenda, which is the Division of Standards Semi-Annual Report. And I'll turn this to Matt Landry, please.
Good morning. Thank you. Good morning, commissioners. I'm going to try to share my screen here. All right. So I'm just going to provide a brief update on the rate of complaints that the Division of Police Standards has been receiving during the last, since my last update in April 2025. And then I'll give you the same update on the status of our disciplinary cases. So I just have 2 slides here. Here's the first one. So for the reporting period of April 1, 2025 through the end of last month, we have reviewed a total of 772 complaints filed by members of the public. That doesn't include a greater number of complaints that were screened out for various reasons, duplicates or something that was just screened out for various reasons. In addition to that, we've got law enforcement agencies submitted to us a total of 865 complaints. For purposes of comparison, when I last spoke to you in April of last year about this, that we've had an increase. So about a 17% increase from last year. The weekly rate of complaints, it was around 30 per week last year. That's gone up. I think that a lot of people file complaints on our website. We've made the process to file complaints a little bit easier. I also think the word's getting out there that this ability exists. So as a result, we have seen an uptick in the number of complaints. There's also been a smaller but still notable increase in the amount of complaints that agencies are submitting to us as well. And again, when an agency submits a complaint, that's either because it's a complaint that the agency received from a member of the public, or it's a internally generated complaint that from a member of the agency that has resulted in that. So all of that gets reported to the commission. And then, of course, as we've said before, any sustained allegations by an agency get published in the commission's disciplinary database. Before I get off this screen, I just want to recognize the hard work being done by the intake coordinator team that is responsible for handling all this information. I know the executive director just mentioned a new hire into that group, but let me tell you, this is a small group of people on our staff. They are collectively responsible for receiving and handling a really significant amount of work. This period here is April to February, but for the calendar year 2025, just to put this in perspective, they handled 1,700 public complaints and almost 1,000 additional complaints submitted by agencies. That's a tremendous amount of information. This is the team that every day they're returning phone calls to people that have called us about their complaints. They will sit down with people who visit our office to provide information during pre-scheduled appointments. And internally, they're in charge of reviewing all of this information, deciding what to do with it, whether to share it with an agency for additional context or escalating it for supervisor review. They do a great job keeping all of this information organized, and I'm very proud of the job that they're doing. And I just want to recognize them because behind the numbers, there's a small number of people that are just doing an incredible amount of work, keeping all of this information organized and prioritized accordingly. So thank you to the intake team for everything they've been doing during the last year. My second and last slide is just an update as to our disciplinary workload. Here again, that number has increased from my last reporting period. We currently have 101 active preliminary inquiries. That is an increase from last year. I think when I spoke to you last, it was in the mid 80s. So certainly not only the number of cases that we've opened, but also just the number that we have going on at any one time has increased as well. We've concluded a total of 117 preliminary inquiries with recommendations of discipline. That includes cases that have become final, but it also includes cases where we've closed the preliminary inquiry and the case is still somewhere in the adjudicatory hearing process. We've closed a total of 26 cases without the commission imposing discipline. Those are cases in which we've investigated a matter and then the commission has decided that no discipline was warranted in that case for any number of reasons. There's a total of 73 officers that are at this moment have their certification suspended for either because of a pending felony criminal charge, or if there's been a vote by the commission that the suspension's in the best interest of the public safety. There's also a small number of cases where an officer is serving a suspension as a disciplinary outcome under Section 10 of the commission statute. And then last, the commission has to date decertified a total of 81 individuals. I'm happy to answer any questions, and I hope this update was helpful. Thank you.
Thank you very much, Matt, and certainly thank those who have worked with you on the information that you provided to us. I don't think I see any indication that anybody has any questions. It was a very clear presentation. And with that, we'll move on to the next item on our agenda, the agency certification standards, specifically internal affairs and officer complaint investigation procedures. And I'll turn to Annie Lee, please, for this.
Thank you, and good morning, Madam Chair and Commissioners. So today I will be presenting proposed revisions to the standard concerning internal affairs and officer complaint investigation procedures, IA for short. I will not be asking for your preliminary approval, just any further reactions and feedback you may have. And so, as you may recall, this standard was last before you in January when it was presented for your initial reactions and feedback. Following that meeting, we sought the feedback of the MPTC and its staff as statutorily directed, and it provided that feedback during its February meeting. That feedback, which largely centered on reporting as a basis for the revisions that I'll review for you shortly, a copy of the proposed revisions is available in your packet starting at page 52. And so with that, before turning to the revisions on reporting, I wanted to bring to your attention some feedback that the MPTC provided regarding terminology. The MPTC noted that some agencies have transitioned from internal affairs to professional standards. I believe the justification for that is that professional standards is a little bit more positive and constructive. However, where statute 6E section 5 instructs the commission to certify agencies in accordance with at least 8 standards, including this internal affairs one, that's a specific terminology that is used. We're revising that instead of replacing internal affairs with professional standards, we merely added on. So agencies are directed to develop a professional standards, internal affairs, and officer complaint investigation procedure. That way we retain our statutory language while also including agency preferred language. And so turning to the proposed revisions on reporting, starting with reporting topics, the MPTC asked for clarification as to whether agencies should accept reports regarding real or perceived retaliation. Because this section pertains to the acceptance of reports, the idea being the agency should accept reports and then determine later through the investigative process whether those allegations are founded or unfounded. We propose clarifying that agencies should accept reports alleging actual or perceived retaliation rather than one or the other. On reporting methods, there are two pieces of feedback here. The first is in response to concerns from the MPTC about the suggestion that agencies should receive reports for potential IA matters through, among a variety of channels, an official agency social media account. They raise concerns that social media accounts lack accountability and can be a method of harassment. And so therefore we strike an official agency social media account from those channels through which someone can report a matter for IA. The second and last piece on reporting methods, this is based on a concern from the MPTC about the propriety of having non-officers receive reports for potential IA matters. They stated that in their view, non-officers may not have sufficient familiarity with the department's policies, procedures, laws, and any applicable collective bargaining agreements, which can sometimes help resolve a prospective reporter's concerns. They suggested that if the reporter would not be comfortable speaking with an officer or at the agency and would prefer to speak to a non-officer outside the agency, the better avenue for that would be the commission, as you previously heard from Director Landry. So therefore, we're suggesting that we can revise this to address MPTC's concerns, to strike the original provisions, which are on the left side of your screen, and substitute it with the right one, which then directs agencies to make available to the public information about how prospective reporter may report a potential IA matter to the commission. As Matt previously said in his presentation, it seems that word is getting out there, but by having agencies provide this information, we can ensure that folks are not only hearing it from other people in the community, but also directly from their agency. And so that is the last of these proposed revisions for today. I'm happy to take any questions or hear any reactions the commission may have.
Thank you very much, Attorney Lee. And I don't see any indication that any of the commissioners have any questions. It was a very clear presentation, and you are not asking us to vote on anything today, so we will acknowledge that. And let me move on now to the legal update, specifically the use of force model policy. And I will turn to Heather Hall initially, and then to Annie for comments on this.
Thank you, Chair, and good morning, Chair and Commissioners. As you all know, the draft model use of force policy was submitted to the MPTC and POST during the week of February 16th. We invited comments on those on the draft, and those comments were due by March 2nd. Just want to note that there were multiple entities and individuals who provided feedback, including law enforcement entities, civil rights groups, and interested individuals. And we want to thank everyone who took the time to review the policy and to provide their feedback. We also want to thank the MPTC for their continued teamwork and collaboration on this important project. With respect to the evaluation process, the working group reviewed, considered, and discussed all the comments that we received. We held 3 meetings over several hours since the March 2nd deadline. Some of the comments did not result in changes to the policy. And for reasons, for example, some suggested changes to language that had already closely tracked the regulations. And some, after discussion, we felt were more appropriately left for either training or other policies that law enforcement agencies are required to have. And I would just note that the working group really carefully considered and sometimes debated various legal requirements and operational factors in evaluating all of the feedback that we received. And I also just will say, as the chair mentioned, that Annie Lee is going to be discussing the comments in more detail, including some of the changes that we did make to the policy. And with that, I will turn it over to Annie.
Sorry about that. Thank you, Heather, and good morning again, Madam Chair and Commissioners. So to sort of summarize quickly the comments, Post and the MPTC received comments from a combined total of 16 distinct entities and individuals. Those comments ran the gamut, which ranged from, process to themes that should be stressed more throughout the entirety of model policy, and in the eyes of others, maybe a little less. There were also comments on the structure of the model policy, suggested definitions, and again, in the eyes of some others, some unnecessary definitions, some specific substantive concerns, and questions seeking clarification. A chart of the comments is available in your packet starting at page 124. The original individual comments are available in a separate SharePoint folder, which was shared with you earlier this week. We can, of course, bump that to the top of your inbox if you'd like. And so, as Heather mentioned today, I plan on presenting for the commission some of the key substantive comments that we received, as well as corresponding recommendations from the group of POST and MPTC staff that reviewed these. When I say key substantive comments, some of which you can see on your screen, I mean by that comments that were shared among multiple commenters, comments that get at the heart of a provision in the model policy, as well as comments that are in conversation with statutory and regulatory directives, as Heather alluded to. When I say recommendations from the staff group, I want to emphasize that there was a lot of work that went into those recommendations. And so while those recommendations were not always or necessarily unanimous, they belie robust discussion, a multitude of perspectives, and compromise. And so, as you can probably tell, I do not plan on reviewing for the commission every comment that was received, nor every revision that was made. However, a redline copy of the draft model policy is available in your packet, and that shows all the revisions, and that's available starting at page 78. I'll be making references to the policy in the next part of my presentation when I provide I'll be providing the page numbers. Those are the page numbers in your packet to the redline copy. And so, as you've already seen, here are some of the key themes and topics among the comments that we received. Those themes and topics on the overarching side, when I say overarching, it means that this is a theme that applies not to any specific section, but to the policy as a whole. That included mental illness, bias-free policing, and youth. There were also comments on specific items, whether it was comments based on a specific thing that exists out there, like Barnes versus Felix, or a specific provision or topic that is within the policy itself, such as specialized units, force limitations and restrictions, parts of the body likely to cause death or serious bodily injury, mass demonstrations, duty to intervene, carrying weapons while consuming alcohol or intoxicating substances, use of force reporting, body-worn cameras, and summoning supervisors. And so I will start with the overarching themes that were present in the comments. On mental illness, the overarching comment here was that many interactions between law enforcement and individuals experiencing mental health crises do not involve a threat of violence, yet can escalate rapidly when symptoms are misunderstood. To address this comment, the commenters here suggested the commission should do three things. The first is define mental illness. The second is provide examples of how mental illness may manifest during law enforcement encounters. And the third is to utilize crisis intervention teams for those individuals who are experiencing mental crises. And so in general, the staff group does not recommend any revisions, as it feels the policy accounts for mental illness in two distinct places. Those places are within the general policies, which is section Roman numeral 4A3 and 5. In your packet, it's at the bottom of page 82 and the top of page 83. The first one is in general procedures. Officers are encouraged to be conscious of non-criminal factors, which includes but are not limited to an individual's mental condition, such that an officer should consider modifying their de-escalation tactics and techniques. The second place in which it also appears, or in which mental illness is also addressed, is also within general procedures at 4A5. Again, that's the top of page 83. And that provision says that when time and circumstances reasonably permit, officers shall de-escalate by, among other tactics, summoning a form of a different response available to the agency, such as co-response, alternative response, or if available, a crisis intervention team. The next overarching theme that we heard comments on was on bias-free policing. One commenter stated that the proposed policy should more clearly recognize and address the role of implicit bias throughout its provisions governing officer decision-making and use of force evaluations. And to that end, they recommended that the commission do two things. The first is define implicit bias, and the second is require implicit bias training. Another commenter made a similar comment saying that there's a statutory right to bias-free policing that should be infused throughout the policy. And so there are 4 discrete revisions that the staff group recommends to this model policy to highlight that right to bias-free policing. The first revision is in the middle of page 78. It's in the policy section, which is Roman numeral 2.1. And that is to reinforce, and the recommendation is you can reinforce the commitment to implementing use of force policy, quote, in a manner that is fair and unbiased, consistent with General Laws, Chapter 6E, Section 1. And so that's, again, incorporating that, a reminder of the statutory right to bias-free policing. The second revision is to define implicit bias as an unconscious attitude or stereotype that affects how people perceive and interact with others. That definition is in section 3 of the policy, and it's at the bottom of page 80. The third revision is to encourage officers to, quote, be mindful of the role implicit bias can play in their interactions with individuals, especially in stressful situations. And that revision is at the bottom of page 82 within general procedures at Roman numeral 4A3. And finally, the last revision to account for these kind of comments is to require agencies to analyze use of force incidents and complaints, including analysis of characteristics, including but not limited to known or perceived protected class characteristics, of which race is one. And so that revision can be found in the middle of page 99 in Roman numeral 404E Romanet 7. The last thematic comment that we received is on youth. And there were essentially 2 kinds of feedback that was provided on youth. The first was this general feedback to harmonize the model policy with the Juvenile Operations Agency Certification Standard, which the Commission preliminarily approved in January. The second set of comments were more specific, and these were specific provisions that the commenter thought warranted an explicit contemplation of or expansion to use. And so that includes in the use of handcuffs, the use of force on or near youth's heads, the use of dogs on youths, expanding requirements to be aware of surroundings prior to using force to include the presence of youth, restricting the use of ECDs and CWs on youths, and required training on the use of force with youths and other vulnerable persons. Here, the staff group does not recommend any revisions, largely for 2 reasons. The first reason is that determination of force is based on what is objectively reasonable, necessary, and proportionate, depending on the totality of the circumstances, which includes an individual's age, meaning that age alone is not a dispositive factor in whether a certain use of force is appropriate or inappropriate. The second is that some of these specific restrictions that the commentators advocated for here are perhaps more appropriate for the legislature and the courts to articulate first. With that, I'll then turn to the comments that were on specific items, starting with Barnes versus Felix. By way of background, Barnes versus Felix is a 2025 Supreme Court case in which the court elaborated on the totality of the circumstances inquiry that applies to excessive force cases, and it's building upon the Supreme Court's case law in this realm, which is notably also contained in Graham versus Connor, which is a 1989 Supreme Court case. And so just a quick summary of Barnes versus Felix. Barnes versus Felix is based on a 2016 incident in which the defendant Felix fatally shot the plaintiff Barnes during a traffic stop in the Houston area. The officer Felix here had pulled Barnes over for suspected toll violations. During that stop, he asked for Barnes's license and proof of insurance, which Barnes was unable to locate. Barnes' documents might be in his trunk, so Felix asked Barnes to open the trunk, and Barnes did, and he also turned off the engine at the same time. Felix then directed Barnes to exit the vehicle, Barnes opened the door of the car, but did not exit the car, and then turned the engine back on, and it started moving. Felix then unholstered his firearm, and as the car began to move forward, he jumped onto the door sill of the car. His head was above the roof of the car, so he didn't have any visibility into it. And then he fired his gun twice, hitting Barnes, who then died on the scene. This happened in the span of, I believe, the engine turning on to shots being fired in approximately 2 seconds. So it was quite fast. The court here, the Supreme Court, held that excessive force claims under the Fourth Amendment should be evaluated based on the totality of circumstances and not solely the moment an officer perceives a threat. And so, therefore, courts are not limited to their review to what was previously called the moment of threat inquiry. I'll highlight this as a unanimous opinion by the Supreme Court. The court here stated the Fourth Amendment's objective reasonableness standard requires a fact-specific contextual examination of all the relevant circumstances leading up to a law enforcement officer's use of force, including events occurring before the instant an officer fired a weapon. That may affect how a reasonable officer would have perceived this situation. And so, again, the holding was that prior actions by either the officer or a subject may clarify behaviors or shift how threatening a situation reasonably appeared. And so, based on Barnes versus Felix, there was a comment that there are essentially 2 buckets of feedback. The first bucket of feedback is that in general procedures in Roman numeral 4A2, which is at the middle of page 82, which prohibits the intentional employment of tactics that are likely to necessitate the need for force or escalate the level of force necessary to resolve an encounter. In general procedures, that should be expanded to prohibit reckless and negligent escalation of force. Because otherwise, in the commentator's view, as written, the policy leaves a gap for officers who may make reckless or negligent tactical decisions and create dangerous conditions through poor judgment and not malice. So in their view, there's a gap for those kinds of decisions. The second bucket of recommendations that they made was to factor pre-incident conduct into the reasonable analysis at the beginning of the policy. So therefore set the stage with a standard, and as well as at the end of the policy into use of force administrative review. So articulating the standard both before force is used as well as after force is used to make that consistent throughout. For that first bucket of recommendations, which is closing this gap, the staff group does not recommend any revisions for 2 reasons. The first is that it is clear to prohibit intentional escalation of force. And second, reckless and negligent escalation of force is perhaps more appropriately addressed in training. On this second bucket of recommendations, requiring that pre-incident conduct be factored in a reasonableness analysis during the use of force, there was one discrete revision, which is at page 82 in procedures at Roman numeral 4. And that revision is to articulate that the totality of circumstances, and again, that applies to the use of force, includes but is not limited to an officer's own technical decisions and conduct leading up to the use of force. The next piece of specific feedback is on specialized units. Here, the commenters suggested that the policy should call for specialized units such as SWAT to be contacted to assist in violent situations and resolve crises. We had another commenter who said it may be impractical to summon an alternative response, especially where there are limited resources. So is it really appropriate to sort of make this reference to alternative response or specialized unit in this model policy? And to that, the staff group does not recommend any revisions, as the policy already includes language to address both of these comments. And specifically, the policy at general procedures in Roman numeral 4A5, which is the top of page 83, says that officers are directed to summon a difference response model so long as one is available to the agency. So getting at that resources question, and to call in specialized units when time and circumstances reasonably permit, addressing that first comment that you see on your screen. The next set of feedback was on force limitations and restrictions. We had different kinds of comments here, one of which was force should be prohibited as an intimidating measure. The second was raising concerns about what was perceived as a total ban of chokeholds as a use of force option. Here, the commenter said that chokeholds may be needed as a self-defense mechanism, and therefore chokeholds should be permitted as a lethal force option on the same level as a firearm. Here, the staff group does not recommend any revisions. Intimidation may be a de-escalation tactic, may help safely resolve an encounter. And second, chokeholds are already banned as a force tactic, not a self-defense mechanism. But they are banned as a force tactic pursuant to the Post Commission's governing statute, as well as the Post Commission's use of force regulations. Next, on body parts of the body likely to cause death or serious bodily injury. Here, there was an ask that the Commission and MPTC clarify what appropriate target areas and parts of the body likely to cause death or serious bodily injury are, so that officers who use force can understand which body areas are appropriate and which are potentially deadly. Here, the staff group does not recommend any revisions, as this can be addressed in training. The next set of comments concerned mass demonstrations. The comment here was that it appears that the model policy places quite a good amount of work on an agency to prevent the escalation of violence during a mass demonstration. However, the staff group does not recommend any corresponding revisions, as the provision regarding mass demonstrations closely follows the requirements articulated both in statute as well as the Commission and MPTC's use of force regulations. The next set of comments relates to the duty to intervene. There were questions about who the duty to intervene applies to. Does it apply to merely officers within the same agency? Does it apply to one officer in one agency observing an officer in another agency using what may potentially be excessive force? There was a suggestion that officers should intervene only when they observe conduct that objectively contradicts or grossly departs from standard and authorized methods and techniques. And the idea there was to sort of help preserve unit discipline and trust among officers. If officers are second guessing themselves, they thought that could lead to an erosion of hierarchy and cohesion among the unit. And here, to the first comment, the staff group recommends clarifying that the duty to intervene and report excessive force applies regardless of the rank or agency affiliation of the officer. So if I'm an officer for Boston and I see an officer from Lawrence using excessive force, a duty to intervene would apply. So it applies across agencies. However, the staff group does not recommend any further revisions, as the standard for intervention is set by statute in Chapter 6E, Section 15, and has been expounded on in the use of force regulation. The next piece relates to carrying weapons while under the influence. We received a few comments on this. One comment was that the prohibition on carrying weapons while consuming or under the influence is too broad. A commenter said that an officer can consume without being impaired and reaching a blood alcohol content of over 0.08, which is the legal limit. And they also raised concerns that a prohibition on firearms or weapons may also sweep in personal weapons that an officer may happen to carry, such as a pocket knife. There was also another comment that said that while officers engaged in undercover work need to be able to consume and imbibe while on duty in order to pursue leads and witnesses and do all that undercover investigative work. And so here, the staff group recommends revisions that address concerns about consuming and personal weapons. The recommendation here is to clarify that the prohibition applies to any firearms or agency authorized weapons. So that way it doesn't sweep in the personal weapons thing. And then also recommends striking consuming from this provision. So officers shall not carry or use firearms or agency authorized weapons on or off duty while under the influence of alcohol or controlled substances. These revisions can be found in the weapons restriction, which is in Roman numeral 4, K7G. It's at the bottom of page 92. Next is on use of force reporting. One of our commenters suggested there should be an emphasis on the duty to report certain uses of force to the FBI's National Use of Force Data Collection Database. They said that although this is already required in regulation, it seems to have not been uniformly followed across all agencies. So they suggested requiring at least monthly reports, including 0 reports. The staff group does recommend a revision consistent with this comment, and it's to clarify that agencies are required to report certain use of force incidents to the FBI at least monthly in accordance, and this is consistent with the FBI's reporting procedures, and they're the folks who maintain this database. That revision can be found in the use of reporting section at Roman numeral 4 and 5, which is at the bottom of page 95. Our penultimate specific comment relates to body-worn cameras. Some commenters said that the model policy should reference requirements to follow body-worn camera policies, including a requirement to activate body-worn cameras when there is an incident with an apparent potential for violence. Another commenter said that the model policy should require that body-worn camera footage be reviewed as part of use of force reviews. Here, the staff group generally does not recommend revisions. Agencies that have body-worn cameras are required to have a body-worn camera policy as a condition to funding from EOPS, and body-worn camera requirements are more appropriately addressed in that policy. However, to at least acknowledge the existence of a body-worn camera policy, we do recommend a limited revision in officer responsibilities when reporting use of force. That is at Roman numeral 4 and 5, the bottom of page 90. No, sorry, have that citation wrong. Apologies. But that revision is to say that when an officer uses force, whether on or off duty, the officer shall, if applicable, preserve any body-worn camera footage in accordance with that policy. So an acknowledgement of the existence of the body-worn camera policy, but also saying, you should look over there to follow those requirements. The last piece of specific feedback we have relates to summoning supervisors. Commenter said that the policy should specify when supervisors are required to be summoned to the scene of a use of force incident. So in other words, when it's a low use of force incident, maybe supervisors don't have to be summoned immediately, but for very serious uses of force, officers should be required to notify supervisors to report to the scene immediately. Another commenter said that supervisors should be immediately requested to respond to a use of force incident, regardless of the level of use of force, as soon as possible. So just whenever force is used, try to summon a supervisor as soon as you can. Here, the staff group does not recommend any revisions, as the policy addresses the summoning of supervisors without being overly prescriptive. That section is in reporting procedures at Roman numeral 402A Romanet 1, which is at the top of page 97. Officers there are required to, quote, notify a supervisor of the incident as soon as circumstances allow. So it allows just the flexibility while articulating this general requirement. And again, this is a model policy. So if agencies do wish to be more prescriptive for their agency, that is something that the staff group thought would be appropriate for agencies to specify on their own. And so that summarizes the specific or the comments and some of the revisions that we made to this model policy. With that, happy to answer any questions or take any feedback the commissioners may
have. Commissioner Crispin, please.
Yes, as it relates to the duty to intervene, the vast majority of conversations I've had with officers relate to federal action that we've seen across the country. And I'm not sure that we've necessarily resolved that issue in the way that with the changes to the policy. But I think it's going to have to be one of those things that we continue to have conversations about, speak to officers across the state, and that's their primary concern about this duty to intervene.
Thank you. Commissioner Bluestone, please.
Yes, thanks. I just had a clarifying question on the distinction that's being made about the consumption of alcohol or use of another substance and being under the influence. And when that term under the influence is being used, I'm wondering what the definition is if it's outside of the context of a driving type standard.
Thank you, Commissioner Bluestone. I don't believe we have a definition for under the influence outside of the driving standard. I'll have to I think we'll have to reach back out to MPTC folks to see if there's a definition that they train on. Happy to bring that back to you, Commissioner, or if you have a suggested definition that you think would be appropriate, also happy to take that to the MPTC to make sure it's consistent with what they train on.
Thank you. I think it's really tricky, actually. I mean, because I think that if there's not a definition there, then it's very subjective, and under the influence could come to mean the same thing as just any consumption. So I would just suggest that maybe we look at that a little bit more closely and try to come up with a way of making it clear what we mean.
Thank you.
Thanks.
Commissioner Talley, please.
Oh, thank you. I'm sorry. Thank you, Chair. On the section about public demonstrations, where it alluded to the fact that police should de-escalate situations, I'm assuming within that statute there's a process that they would use to de-escalate, or a procedure they would use to de-escalate.
So for mass demonstrations, there's planning requirements that our regulations require. And so it requires that someone within the agency who's designated to plan for a mass demonstration event do their very best to reach out to the coordinators of the mass demonstration events to try to get an understanding of what is being planned so they can anticipate numbers. And they're also required to engage in communications with the organizers of a mass demonstration so they can start sort of making logistical plans for de-escalation if it comes to that point. When it actually comes to the day of or the time in which a mass demonstration is taking place, those plans would theoretically kick in, or if they're still appropriate, they would kick in. But then also at that time, officers would be asked to, if when necessary, to de-escalate in accordance with their training. And I think that would incorporate de-escalation tactics that they use on the streets every day in smaller encounters, but also perhaps some of the larger de-escalation techniques and plans that they've been taught on in advance of such an event. If that helps answer your question, Commissioner Talley.
Okay, thank you.
Are there any other questions or comments from my fellow commissioners? I don't think I see any indication of that. Annie and Heather, thank you very much for your presentations. Now, as I understand it, you are looking for a vote from the commission on this extraordinary work that has been done on this use of force model policy. You are looking for a vote, is that correct?
Correct.
All right. Let me ask then for a vote. Commissioner Bluestone?
Yes.
Commissioner Calderon?
I
I
don't see him on
actually
the screen.
don't see him on the screen, Madam Chair.
I'm sorry, let me see if we go through and if there's some way to
I'll see if I can text him.
thank you so much. Commissioner Crispin?
That's a yes for me, Madam Chair.
Thank you. Commissioner Hall?
Yes.
Commissioner Kazarosian?
Yes.
Commissioner Luma?
Yes.
Commissioner Talley?
Yes.
And I'm also a yes. I think we have, let me see, can we?
We have a majority so far already, rather.
And I just have had a text, I'm sorry, from Commissioner Calderon. He apologizes. He is unable to continue to participate on the Zoom. And so I think with that, we have a necessary quorum affirmative vote on this issue. Let me again thank everyone who has participated in the extraordinary presentation, particularly the members of our legal department, Heather Hall and Annie Lee, and our general counsel, Randy Ravitz, for the work that you've done. Let me also thank the members of the public who have commented. I think the breadth and the nature of the comments here just demonstrate the extent to which I think we've had a very broad swath of the public involved in this issue in coming up with what the present now adopted use of force policy of the commission is. And I know I speak for all the commissioners in expressing gratitude for the extraordinary work in developing this policy that has occurred.
Here.
And I think with that, we move on to item number 7. There are no matters not anticipated by me at the time of of posting, I should say. And I would now entertain a motion to move into executive session in accordance with Mass General Laws, Section 30A, Section 21A1, to discuss the discipline or the dismissal of or complaints or charges brought against a public officer, employee, or individual. The same statute, Section 21A5, to discuss the investigation of charges of criminal misconduct. The same statute, Section 21A7, combined with General Laws, Chapter 6E, Section 8C2, and to the extent they may be applicable, General Laws, Chapter 6, Sections 168 and 178, to discuss matters relating to preliminary inquiries and initial staff review concerning whether to initiate such inquiries and regarding certain criminal record information, and the same statute, Section 21A7, combined with General Laws, Chapter 38, Sections 22 F and G, to discuss and to approve prior executive session minutes. We will be addressing divisions of standards reports of preliminary inquiries in 5 cases. We will be addressing division of standards requests for approval to conduct preliminary inquiries and or to impose a suspension in 5 cases. We will also have a suspension hearing in the matter of Darnell Campbell Jr., and we will be addressing approval of the minutes of the executive session of our last meeting on February 19th, 2025. So with that, is there such a motion?
So moved. This is Marsha Kazarorgan.
Is there a second?
Second.
Thank you. Commissioner Bluestone,
Yes.
Commissioner Crispin,
Yes.
Commissioner Hall,
Yes.
and I think Commissioner Kazarorgan initiated the motion. Commissioner Luma,
Yes.
Commissioner Talley,
Yes.
and I'm also a yes, so that's unanimously carried. Again, let me thank the members of the staff who have worked on the matters that we've addressed today. Let me thank the presenters for the clarity of your presentations and all the written material that you provided to us. I think the volume is extraordinary, and I'm sure the public joins me, as the fellow commissioners do, in applauding all the work that you've engaged in. Members of the public, we will not be returning to the public meeting after the executive session. And I think, Enrique, if you wouldn't mind, again, as I think you did at the beginning, just explaining to the public, if they wish to comment on anything that we've addressed today, how they can do that.
Yes, thank you, Madam Chair. Let me share the last slide of my presentation, which are all the resources that we typically announce. They can call us at the number there, contact us via the website, mapostcommission.gov, or send a comment to posty-comments@mass.gov.
Thank you. And we will take, commissioners will take a break of approximately 5 minutes. I think the information for Zooming has been provided. Jamie, you've provided that again to us, have you? Thank you. So we will reconvene, commissioners, with the additional Zoom information that Jamie has provided in approximately 5 minutes. And again, thanks to all the presenters, thanks to members of the public, thanks to the staff for all the work that's gone into this meeting.